Sadly, when my colleagues across the aisle passed the Reproductive Health Act, they nixed a key part of the public health law, Section 4164, which required doctors to report all life-sustaining efforts, their failure or success, for infants born as a result of an abortion procedure. Currently, as a result of this, there are no reporting or care requirements for infants born alive as a result of an abortion procedure known as induced termination. But these records arguably hold the same public health value as the bill before us. And the goal with both bills is to sustain life. The Centers for Disease Control has even issued guidelines in these instances recommending the issuance of a birth certificate for infants born under these horrific circumstances and a death certificate in the event of a death. While they say it's not likely to happen, the CDC reports the induced abortion procedure may result in a live birth. Opponents of this amendment contend that infants are not born alive as a result of an abortion procedure, so collecting this data is unnecessary. To that, I say the facts matter. 143. That's the number of infants that have been born alive as a result of an abortion procedure and who subsequently died in the United States between 2003 and 2014. 72. That's the number of infants born alive who subsequently died as a result of an abortion procedure in New York State between 1997 and 2017. While some of those deaths resulted from spontaneous termination of a pregnancy, the fact remains that this occurred in New York before the Reproductive Health Act and will certainly continue now that the law allows abortions up until the moment of birth. Yet because the RHA removed all reporting requirements, now the CDC will not be able to accurately report on how many infants are born alive as a result of an abortion. Very, very convenient for those who say this horrific loss of life does not occur. The CDC has made it very clear just how important it is to continue this reporting in order to examine trends in public health and to make informed decisions. The reported data has been used to identify characteristics of women who are at high risk of unintended pregnancy, evaluate the effectiveness of programs for reducing teen pregnancies, and monitor changes in the clinical practices patterns related to abortion, such as changes in the types of procedures used and the weeks of gestation at the time of abortion. This information is needed to calculate the mortality rate of specific abortion procedures. This amendment will reestablish these vital reporting requirements that hold as much significance as those regarding deaths from opioids. This proposal in no way hinders a woman's access to abortion, but rather helps protect the life of an innocent baby born in this horrific situation. In the situation where a child is born alive during an abortion procedure, what person in their right mind would believe a doctor or medical practitioner should not provide medical treatment to save or keep the child alive? Mr. President, I offer that this amendment is not a partisan issue. When a very similar bill was brought to the floor of the United States Senate, the bill received bipartisanship support. A very similar version of this bill passed the North Carolina State Senate, with 5 Democratic senators voting in favor of the legislation. One Democratic senator summarized his vote by saying, "How could I vote against my conscience?" It is for these reasons that I urge my colleagues, all of my colleagues here, to support this common sense public health amendment.